Talking about this before the break, trade union NUMSA and the South African cabin crew have condemned SAA for informing workers of its intention to restructure through a media statement. Hundreds of jobs could be on the line at South African Airways. The airline says it's informed more than 5,100 employees that it is embarking on that restructuring process, which could lead to job losses. But the two unions say that workers were not informed. Well, SAA has faced numerous challenges over the years, including high debt, fluctuating fuel prices, insufficient revenue and cash generation, and high operational costs. The national carrier also has an aging fleet of planes, which is costly to maintain. Acting CEO Zux Ramasia says those challenges make it difficult for SAA to compete in the airline industry. Possible retrenchments could affect 944 employees. Ramasia says a consultation process has begun with all employees in line with the Labour Relations Act. The restructuring excludes SAA subsidiaries, SAA Technical, Mango Airlines and Air Chefs. But the two unions say that SAA has not informed and consulted with them about its intention to embark on that Section 189 of the Labour Relations Act move, and they've threatened to embark on a full-blown strike as a result. Chinese e-commerce giant Alibaba's Singles Day, a shopping frenzy yesterday, raked in a whopping record $38.4 billion in sales in the 16 and a half hours of trading, surpassing last year's all-time high. Shoppers in China and across the world snapped up hot items, including iPhones, cosmetics and clothes. The firm said sales reached $1 billion in a little over 1 minute of trading. The shopping festival began in 2009 with participation from just 27 merchants. More than 200,000 brands participated in this year's event. The shopping occasion has since been replicated around the world. All right, we're now going to take you live to a briefing by the South African Revenue Service. The SARS Commissioner, Edward Kieswetter, about to brief the media on the Tax Administration Act. It's live for us in Pretoria. Let's go.
At SARS in the immediate past are still captured. They are still serving the intent which is contrary to the pure intent of administering tax laws, collecting revenue in the interest of our young and troublesome democracy at this time. One would wonder why there would still be so many who would continuously seek to undermine this important work deliberately as we seek to rebuild SARS. And I know that because of information leaks that takes place, and often information that is confidential to SARS, information that is confidential to taxpayers. And I want to again caution such individuals that they are breaking the law as they do so, regardless of their intent. Trust in the organization has been eroded, and the work of rebuilding SARS is underway. But against all this, we continue to work relentlessly, hard, and it will take time as we re-establish a well-functioning, well-governed SARS with integrity. Many of the organizational arrangements which have been impacted, the large business center, the integrity unit, the high court litigation unit, the compliance unit, the illicit economy, all of these capabilities we have commenced and are in various stages of putting it in place so that we can confidently deliver on our mandate as is required of us. All the more, I also would like to say, since today is a matter that has come into the public domain as a result of actions by the Office of the Public Protector, that amongst the many things that I have to deal with as a commissioner is a number of things that requires response out of a list of matters issued by the Public Protector's Office. And I have to say unequivocally that we respect and regard the Office of the Public Protector with the seriousness and earnestness that is required. We have committed to work with the Office of the Public Protector to provide whatever is required. We consider ourselves to be on the same side, which is in pursuit of justice, in pursuit of that which is right, and we will continue to collaborate in that regard. All the more reason why it is extremely important that two such important institutions, such as SARS and the Office of the Public Protector, would work hard to seek to avoid fighting each other in the court and in the process incurring legal costs and scarce resources which could be used in so many other profitable ways. We know that we are currently resource constrained and the country is struggling with financial limitations. And so this briefing today seeks to provide clarity to what has emerged in the public domain. I must also stress that this briefing is not to discuss any particular taxpayer, neither this specific matter, as much as it is to provide clarity to the public regarding an important principle of clarity and certainty which is fundamental to the administration of our Act as we seek an approach of voluntary compliance. So in this regard, let me turn to the specific matters that you would have come across in the public domain. I'm aware that the SARS application to court concerning a subpoena issued by the Public Protector compelling me to divulge taxpayer information has created a lot of speculation in the media, including social media. Healthy debate, which we welcome, is the basis of a good democracy, and a quality engagement of society is a fundamental principle of a strong society, and we welcome this. However, it is important that this debate is informed by facts and rather than by views or opinions, and very often by distortions of the truth, such as many would seek to pursue because it may favor their interests. The SARS application to court is not about a specific taxpayer. SARS has turned to the court to clarify and determine an important legal principle that underscores the democratic principle founded on the relationship of trust between SARS and all taxpayers, including all of you in the room, I might add. This is the taxpayer's right to privacy, which concerns the right to confidentiality of all information, personal and financial, that we hold in trust. It is a privileged position that we have, and we regard this privilege with deep respect and honor. Every single taxpayer in South Africa, therefore, has a direct vested interest in this matter on which we are seeking clarity, and no one can afford to be indifferent in this regard. You could quite rightly ask why anyone, whether an organization or an individual, including the Office of the Public Protector, would not welcome the attaining of such clarity in a matter that clearly has such keen public interest and so much profound impact on all of us. The constitutional principle of public access to information held by the state must be balanced by other constitutional principles, such as that of privacy and other factors such as the overriding risk of harm to a legitimate public or private interest. The interest of a taxpayer's right to privacy, which concerns the right to confidentiality of personal information held by the tax administration, is generally recognized as outweighing the right to information and justifies, thus, confidentiality rules that protects privacy. Thus, Section 35 of the Promotion of Access to Information Act of 2000 provides mandatory protection for certain SARS records from third-party requests. Disclosure of tax information has consequence It has consequence for the core business of any tax administration, the implementation and enforcement of tax legislation and regulation. The collection of taxes is clearly vital for any state financed by state taxes such as ours, and a tax administration's primary responsibility is to collect the proper amount due to the state at least possible cost to the public. The willingness of taxpayers to comply with the law depends greatly on the trust invested by citizens and businesses in the tax administration in question, and their confidence that their personal information will not be generally disclosed. Taxpayers should have their expectations confirmed that the tax authority administering the tax laws does so consistently and fairly, so that similarly situated taxpayers are treated equally and consistently under the law. In balancing of public interests, which may often be competing, I might add, the legislators who drafted the Tax Administration Act clearly intended that taxpayer confidentiality is an overriding interest, unless otherwise expressed in law. This is central to our strategic intent of building an organization based on voluntary compliance by taxpayers. The Commissioner of SARS and all officials are legally compelled to uphold the confidentiality of taxpayers' information, except under specific legal circumstances. The specific legal circumstances do not apply to the public protector. If I or any other tax official break this legal duty, then apart from breaching the public's trust, a criminal offense is committed. At the same time, the public protector's powers enable her to compel the production of information. The failure to comply with her subpoena is a criminal offense, unless there is reasonable cause not to comply. The confidentiality provisions in terms of the Tax Administration Act of 2011, taxpayer information is subject to confidentiality provisions, and this is contained in Chapter 6, specifically Section 67 to 74 of the Tax Administration Act. And I would urge you to read that. The general rule is that SARS officials must preserve the secrecy of taxpayer information. Section 69, brackets 1 of the Administration Act provides that a person who is a current or former SARS official must preserve the secrecy of taxpayer information and may not disclose taxpayer information to a person who is not a SARS official. And I might add that every single one of us take an oath of secrecy, and whether we are currently employed by SARS or whether we choose to leave the employment of SARS, this oath of secrecy is binding in law, and therefore I again would urge those current SARS employees and those who have left, including those who have left recently, that if they do not observe this provision, this oath of secrecy, they are breaking the law. And we know the law may be slow, but its arms and its reach is long and wide, and eventually each of us will account for our misdemeanors or acts of transgression in law. There are, however, I would like to clarify, specific provisions that does allow taxpayer information to be disclosed to a person who is not a SARS official. These circumstances can broadly be categorized into 5 areas, and as I said, more of this detail is in the Act. A SARS official can divulge taxpayer information in order to administer a tax act. Secondly, we may divulge information if required to do so in terms of a court order. Thirdly, we may divulge such information if a taxpayer gives us written consent. Fourthly, if another act expressly overrides the Tax Administration Act confidentiality provisions in terms of Section 69, brackets B of the Act. And lastly, to certain persons and entities identified in the Act in terms of Section 70 of the Tax Administration Act. Then I would also like to add that the following acts contain provisions that expressly override the tax confidentiality provisions. And it's important that you also take account of these. And I will share with you three. Firstly, Section 9 of the Drugs and Drug Trafficking Act of 1992. Secondly, Section 37 of the Financial Intelligence Center Act, the FICA Act of 2004. And thirdly, Section 71 of the Prevention of Organized Crime Act, POCA, of 1998. I must stress, the Public Protectors Act of 1994 does not contain a provision that overrides the confidentiality provisions of the Tax Administration Act. Section 70, for those who are keenly interested, lists certain entities that SARS may provide information to, but subsection 70.5 provides that such disclosure may be made only to the extent that it is necessary, relevant, and proportionate to the exercise of a legislative function or duty. Further disclosure of such taxpayer information by entities to whom we disclose under this provision is strictly prohibited. In the case of parties permitted in law, even under these circumstances, SARS has to demonstrate that it has applied its mind to the purpose for which the information is being requested, how it will be used, and how it will be protected. The ultimate responsibility for this protection of this information sits with SARS in terms of the authority vested in the Act. The essence of the summary of the Tax Administration Act is that it does not allow SARS to provide taxpayer information to the public protector. Now, the untenable position that the subpoena has placed the Commissioner in is akin to being between a rock and a very, very hard place, with significant personal legal consequences, including committing a criminal offense. So on the one hand, the provision of taxpayer information, if our understanding of the Tax Administration Act bears out, which we believe it does, if we were to provide the information, it would be a fundamental breach of the Act's confidentiality provision, and that would mean the Commissioner would commit a criminal offense in terms of Section 236 of the Act simply by providing the information. At the same time, by not responding to the subpoena and the request for information by the public protector, the Commissioner would equally be guilty of a criminal offense under Section 11.3 of the Public Protector Act of 1994. So you can see this huge conundrum that the Commissioner is faced with, that whatever the Commissioner does, it runs the risk of breaking a law and in person committing a criminal offense for which there is personal liability, including imprisonment. So I take this matter extremely seriously, because ultimately it is within the Commissioner's accountability to administer this Act in a way that is beyond reproach and legally permissible. I must point out, in the interest of transparency, that in 2018, in the previous tax year, in an attempt to avoid, when this request was initially made, and in an attempt to avoid litigation, the officials from SARS and the Public Protector's Office decided that they would jointly brief counsel to seek a clear legal opinion, which legal opinion was provided to SARS and the Public Protector, which clearly sets out, in my mind, and confirms that SARS cannot be compelled to provide taxpayer information to the Public Protector. The Public Protector's Office is in possession of this legal opinion in the same way that SARS is. Earlier this year, as an act of, as required in terms of cooperative governance, but also as an act of goodwill, since I had never met the Public Protector personally, I had a conversation, a discussion, and unequivocally expressed my support for her office and for the work that is done by the Public Protector. In many instances, we have a number of matters that we currently deal with. Those are the matters I've inherited that require our response. And I must say that it is keeping us extremely busy, by the way. We as a team, we work diligently to respond to every single information request. And it can be on the public record that we have done so without fault. And we will continue to do so, because the work of the Public Protector is central to the success of our democracy. In our meeting, I also personally expressed that we should keep a line of communication open. You know, SARS and the Public Protector, we are on the same side. We work in the interests of the society, in the interests of our democracy. We are not adversaries of each other, and we shouldn't behave as adversaries of each other. In this spirit, I made a request that not only would we continue to work diligently to support every single matter that requires our cooperation, but where required that we rather have open and frank discussions, and where we may disagree on a matter, as would be the case, because law can sometimes be interpreted differently, that instead of resorting to legal and expensive recourse, that we sit around the table and see if we can come to some agreement, and in instances where we can't, that we would use the court of law to obtain legal clarity, because that, I believe, advances our cause, our common cause, the common cause between SARS and the Office of the Public Protector, which is to strengthen our democracy and to ensure that it is well functioning and capable. This is our position. The subpoena issued to me was therefore taken me by surprise, as I believe that the goodwill expressed would be reciprocated in the interest of good governance and in the interest of the constitutional principle.
Thank you very much. We have accelerated the program
All right, we've lost that feed to Pretoria, where we were hearing from the SARS Commissioner, Edward Kieswetter. We'll see if we can take you back. But let me tell you what this is all about. The Public Protector is not mentioning names. He said this isn't about one taxpayer specifically, but she has requested the tax records of former President Jacob Zuma. And that's after a DA complaint to the Public Protector. It wants to find out if the former president did receive payments that were undeclared from a security company that was outlined in a book saying that he received 1 million rand per month. And Edward Kieswetter is saying that the law needs to be clarified. He's between a rock and a hard place. He may be breaking the law by handing over those tax records, given the former president's right to privacy. Let's take you back to that briefing in Pretoria now.
How to uphold as Commissioner for the benefit of all taxpayers. The principles are not limited to the taxpayers cited in the court documents. So don't get hung up about the names. We have always said we act without fear or favor. This is about a legal principle, notwithstanding the names, that affect every single one of you as tax-paying South African citizens. And you should have a vested interest in this. You should want this clarity. The principles will define, and for that matter, it advances the work of voluntary compliance. If at any stage a taxpayer would consent to the reader's information, then SARS would gladly respect such consent. Equally, if a court of law orders that I am required to release such taxpayer information, equally we would, without hesitation, comply with such an order. I view this matter of clarity as singularly important for the democracy of South Africa and as a further building block to fulfilling my commitment to rebuilding public trust and confidence in SARS. It is in this spirit that the application to the court was made. And I believe that, given this, when the court, I have to also say that I'm encouraged this morning that the parties agreed, endorsed by the courts, that we would stay the subpoena, we would not exercise the subpoena as was initially required for me to fulfill tomorrow, and that we would both appeal and engage the Deputy Chief Justice to ensure that the substantive matter of taxpayer confidential, of whom SARS may provide, other than is set out in law, confidential taxpayer information to, is clarified, and we would work together to urge the court to hear this matter. Of course, that doesn't mean that either party compromises on the part of the public protector either their right to reissue the subpoena or on this part of SARS to again apply for the relief that our first application, which was heard today, sought. I think that provides the clarity, but as these issues can be quite intricate and of a legal nature, we would happily take questions. And so I'll hand back to Sipiti.
Thank you very much, Commissioner, for that statement. Distinguished colleagues, journalists, you have heard the presentation by the Commissioner. If there are any questions, please just raise your hand, and the colleagues with the roving mic will be able to give you the mic. Thank you. Is there anyone who wants to? Thanks, ma'am. Thanks, ma'am.
Good afternoon, Amanda Fisser from London. I just want to have clarity for myself, so the subpoena is being stayed. You are seeing the Deputy Chief Justice for negotiation, and the decision will be in his hands on what your position is. Am I understanding incorrectly?
So the implementation of the subpoena is held in abeyance, which means that tomorrow will not take place. I will not have to, as previously required by the subpoena, present myself and present the information as requested and required by the public protector. That does not mean that either party give up their right to reinstitute a subpoena within the 15-day provision that is required, to which the Public Protector's Office has agreed, and neither does it mean that SARS may not, again, apply to the court to have the subpoena set aside subject to the substantive matter. On the substantive matter, what the parties have agreed, which is the encouraging part for me, is that we will continue to engage the court to seek clarity of this legal principle. And hopefully, in the spirit that this clarity strengthens our democracy, the public protector would, together with SARS, create the space and the time for the legal clarity process through the court to indeed take place. As I said, there can be no conceivable reason why any of us, including SARS or the public protector, would not welcome such clarity.
Thank you, Commissioner. Another question?
Deputy Judge Wonders.
Thanks, ma'am.
I'm Sibongile from P24. I just want to find out from the Commissioner, should the court grant the order in favor of the Public Protector's Office, what sort of implication will this have on SARS, or what sort of precedent will it set?
So there are two things. So firstly, SARS will apply and abide by any court decision. And so we're very clear that if in this specific instance the court issues an order that we release the information of a specific taxpayer, SARS will do so. That does not set a general principle for the release of all taxpayer informations, because the provision of the law is the public protector has one of two routes to go. The first is on a case-by-case basis to apply to the court for the release of taxpayer information that relates to a specific taxpayer, and that would be a case-by-case basis. The more general route would be to have the powers of the Public Protector Act amended in terms of the legislation process, or to engage the Minister of Finance and request that the Tax Administration Act be amended to include the provision of and to set a general principle of the provision of taxpayer information to the Public Protector.
Thank you, Commissioner. Yes, ma'am.
Sorry, I didn't hear the name.
Naledi from the SABC.
Hello, Naledi.
I want to find out who this individual is. I want to find out whether he had a similar case on hours of dealt with. Is it something new, the fact that South Africa decided to
First of all, sure, thank you, Naledi. So first of all, for the principle of clarity that SARS is seeking, this is irrespective of any individual, irrespective of any individual taxpayer. We are not seeking to protect an individual taxpayer. We are seeking to firstly administer our act in a way that is required of us, and secondly, because of the doubt that may be created in the mind of the public or in any other actor's mind, we seek clarity of a legal principle. We are not seeking clarity of a tax matter or of a taxpayer. We get requests from all people all the time, especially the media, for taxpayer information, and we consistently tell you that we will honor our oath of secrecy. And so the only information we will ever disclose is that which is permitted in law.
Thank you. Any other question?
There has been some speculation and some assumptions about the privacy and the secrecy provisions in the Act, and that could be used to protect specific people that you said is not your intention. But given what has happened in the country and given what has happened with people of influence in organizations that has led to the decline in tax collections, in rampant corruption, isn't this in the public interest that certain issues that are in the public's interest can be made public?
So first of all, Amanda, as I have told you and your colleagues before, we apply our act without respect of person, position, or status in society. So the fact that something is more newsworthy for you if it is a person of prominence doesn't matter to us. We certainly do not appeal to the sensationalism that is often or what you may consider newsworthy. When we administer the act, we do so without fear, favor, or prejudice, and we treat every single taxpayer equal before the law. That's the first point. The second point is, what is in the public interest is a matter that requires deep insight and discretion when we apply our own minds, to the extent that there is discretion, which in this case there is none. But let me say that broadly the matter of public interest does not stand uncontested. Public interests often compete. And as I mentioned earlier on, clearly when the legislators drafted the Tax Administration Act, it did consider the issue of public interest. And in considering that, drafted the law clearly expressing the view that the confidentiality of a taxpayer information is an overriding public interest than whether or not we disclose a matter that may generally be newsworthy. And so for me, it in fact does respond to the matter of public interest, but not necessarily in the way that certain constituencies may understand it. But certainly our understanding is that Amanda Visser or any other person has an equal right in law for their personal information as relates to their tax matters to be treated with utmost care, diligence, and privacy. And we will give you the honor and every other taxpayer the same honor.
Thank you, Commissioner. ANC, please, and then we will come.
Thank you, Mr. Goldman. My apologies for arriving here. Commissioner, has SARS ever received the subpoena from the Public Protector's Office in the past? If not, it hasn't, or if it has, how is it?
I mentioned earlier on before you came here, Govan, that the request for information, taxpayer information by the Public Protector's Office has been, is a matter that has historical precedence, and our reaction is exactly the same. This is, to my knowledge, the first time that the Commissioner of SARS is subpoenaed to provide such information.
And then, I may have missed this as well, you say that there's specific provisions in law that allow for taxpayer information to be disclosed, and one of those is if the taxpayer gives written consent. I don't know what the protocol is, but has SARS asked the individual taxpayer whose information has been requested if you will give written consent, or is that not something
that is not how we would work? A taxpayer may be approached by any third party. If that third party believes that it is in their interest to have such information, we do not act as agents of any other agency who may feel they have the right to information. So no, we would not, in this instance or any other instance, seek a taxpayer's consent.
Commissioner Malungelo from Newsroom Africa, I want to quote something you said that you and...
Sorry, where are you? Oh, Malungelo, here you are.
One of the things, you actually said this twice, that SARS and the Public Protector's Office, you're on the same side, you want people to do the right thing. And I just want to get clarity as then, why then would you seek personal court order against the Public Protector if she opposes your case?
Let me be frank about that, Malungelo, because firstly, I referred to a goodwill engagement that said, before we go off and incur legal costs and spend taxpayers' money.
All right, that is SARS Commissioner Edward Kieswetter still speaking in Pretoria. And this is about the public protector trying to access former President Jacob Zuma's tax records. However, SARS are resisting that, saying it wants the court to really clarify an issue which is privacy, and it's not about one individual taxpayers, but the privacy of all taxpayers versus access to information. All right, and this is where we say goodbye to our viewers on SABC3. Thank you for being with us.